not on the outline, but on page 1. We live in California, and California is one of the western 19 states. And unlike Nevada and Wyoming and New Mexico, there is not a statewide regulator of groundwater. There's no state engineer that controls all groundwater extractions and permits. It's never been the case in California. Joseph Sachs once said about California, they don't do groundwater. He wasn't referring to Southern California, however, because even in his point of view, he thought that Southern California, and particularly the adjudicated basins, had done a remarkable job of managing groundwater since the imposition of the adjudication system in the early 1950s. And more or less, his attention was targeted elsewhere in the state. So there is no statewide comprehensive scheme, so to speak, for managing groundwater. And for the better part of 100 years, it was pretty much left to the vagaries of local administration. And there are local agencies in some areas that desire to engage in groundwater management. You have municipal water districts, you have cities, you have counties, you have special districts. And you see local interest and the legislature grappling often with trying to empower agencies to manage groundwater. And in this basin, it's really no different. We have multiple member agencies, you have cities, you have conservation district, you have a plethora of public agencies, each which purports to have some management and control over groundwater. And at its core, you also have common law water rights, which are part and parcel of the subject of groundwater. And the Chino Basin adjudication was really an effort to take all of those competing jurisdictions' common law rights and meld them into a single management structure. And it was quite an undertaking. So to begin with, the underlying litigation, I'm focusing now on page 1, the underlying litigation was a complaint that was brought to adjudicate water rights. And what that means in lay terms is, I think many of you are familiar with what quieting title is about, where you have competing claimants to a single piece of property. They are required to come forward, explain what the nature of their title is, and it's up to a judge to organize and to determine what their relative rights are to that specific asset. And in this case, that asset was what? It was the waters of the Chino Basin. So the complaint itself put at issue the relative rights to that basin. The second thing that it was about is something called a physical solution. The concept of a physical solution was really where some pretty smart engineers got together with some lawyers, and they created the suggestion that maybe strict water right priorities ought not to always control. That is, if I hold the senior appropriate right, most of you know that in the state of California, if you have the right which is first in time, you have the right of priority. And you can use that water against all other takers. You can use that water unless that the person who is junior to you can find a way to take their water without harming you. And if I'm a junior user, I have the ability to mitigate my harm on a senior user. I can go ahead and take the water, even though the senior user would typically have priority. That is, so that everybody can share in the common supply and use the water together. So at the cornerstone of what the complaint in the Chino Basin was about was the question of whether there was a physical solution that would make the traditional priorities not irrelevant, but put them on the back bench, so that there was a way to manage the basin and ensure senior priorities and junior priorities the right to have water. Customary goals in the adjudication were traditional in most adjudications, and that is you want to fill the void in groundwater management, you want to reconcile the differences between the various rights, you want to end conflict, and it is pretty much accepted that planning from a water supply standpoint and from a land use planning standpoint, and certainly from an economic standpoint, requires certainty in administration. And the game of water rights has been analogized to chess, or checkers, or rock, paper, scissors. And if any of you played those games, as I'm sure you have, the outcome is uncertain. And so consequently, the theory of an adjudication is to remove the vagaries of what would happen in a given case, in a given court, and create certainty by a clear set of rules in administration. what is somewhat novel, not completely novel, but somewhat novel, is that the judgment in this case was entered by stipulation. But the thought was, when the adjudications initially started, they would last 10, 20, 30 years, and the lawyers and the engineers in the process would be paid handsomely throughout that process, and they would take a very long time. But after we started to get some experience in the state, some clear precedent, people began to be more creative, more businesslike, more thoughtful, and try to come up with ways to manage a basin without waiting for the judge to decide. So what is that? Well, it means we sit down, across the table, and we negotiate rules and terms and conditions, and we reduce those things into a settlement agreement. And by the way, all the lawyers can tell you that a settlement agreement is nothing other than a contract, right? It's a contract. So in this instance, the parties got together and they decided they were going to enter a judgment by stipulation. But then they also wanted to do something else, which was today required, and that is they were going to take that stipulation, that contract, and they were going to run it over to a courtroom, and they were going to have a judge approve that contract. And the authority for the judge to do that comes from basic approval of settlements, but once we entered the area of water, it was a little different in that there's this provision called Article 10, Section 2 of the California Constitution. And that requirement means that the reviewing court has to take a look at what the promises are in the underlying contract and find that they are consistent with the provisions of the Constitution. It basically mandates the reasonable use of water, and the cases under that discuss maximizing the reasonable and beneficial use of water, the idea that water in California should not be put in cold storage. The economy in the state of California is driven by use, and we want to put the water to use. We want to put it to use responsibly, but we want to put it to use. And the more water we can put to use responsibly, the better we are, and the higher value of the overall efficiency of the effort. So in this instance, at a contract, stipulation goes to the court. The court's asked to approve it. And so what the court does in issuing its approval, mind you, it did decide that this stipulated judgment was in the public interest, and it found that it had subject matter jurisdiction. That's important. It had subject matter jurisdiction for the lawyers again in the room. It had jurisdiction over the race, which was the water. When we talk about the race, we talk about the thing, we talk about property. It could be a car, it could be a house, it could be land. In this instance, the court concluded it had subject matter jurisdiction over the water, which ultimately is going to become important for the subject of replenishment and storage. Second thing is it said it had personal jurisdiction. It had personal jurisdiction over all the producers. So now you got a jurisdiction over the race, and you have personal jurisdiction over all the producers from the basin. The court approves the settlement, saying that it's consistent with Article 10, Section 2, and wasn't here in 1978. I was sitting out at the University of Redlands in a geology class. But at that point in time, the court also did something which was, it said, we're going to exert our authority here, and we're going to enjoin any production from the basin that's not in conformity with the decree. So all outsiders or all insiders are potentially subject to this court's jurisdiction over the people and the race, and they are not entitled to use water unless it is in conformity with the judgment. So that's the first thing. The second thing, which is very important, and I think the modern cases actually say that this court was right on, and in fact it had to do this. But the parties by contract gave the judge continuing jurisdiction to administer the decree. So, the rule is that you usually have one judgment. You go to trial, the judge bangs the gavel, issues the decision, and you're gone. In water cases, particularly in adjudication, the exception is more or less the rule, where the court will issue the judgment, but then reserve jurisdiction to issue further orders to redress evolving circumstances, changing conditions. And the Supreme Court and Courts of Appeal, since that point in time, have acknowledged in the area of water that's really required, because the facts and circumstances as they exist today on the ground are different with the passage of time. We learn more about technology, and we learn more about the environment. We learn more about water use, water quality. And I think the Chino Basin is representative, the experience of the Chino Basin is representative of that experience. So, by contract, the parties provided for continuing jurisdiction. So that's important. It wasn't the court on its own saying, hey, we're going to reserve continuing jurisdiction. The parties defined the areas of continuing jurisdiction, and sort of there are different perspectives within the Chino Basin family about what that means and what the court was doing, and what the court's authority really is with regard to the reserved jurisdiction clause. There are some people in this room who take the point of view that the court's jurisdiction over the subject matter is an inherent, part of the inherent powers of the court, and effectively the court is able to get to the subject matter and under change of circumstances has the power to revisit even the contractual arrangements that were made by the parties. There are then the strict constructionists who on the other end say, no, this is a subject matter limitation on the court. The settlement was offered with these express and reserved areas where the court can go and cannot go. And so the reserved jurisdiction does not allow the court to do things like modify people's percentages of operating safe yield. And these things were exempted from the continuing jurisdiction of the court. And then within that framework, you have the Chino Basin Water Master, which is a water master functions typically pretty freely in the West and in almost every area where there has been a determination of rights among competing users. In Southern California, we kind of morphed the definition of what a traditional water master is into being a more active management entity. So Chino Basin is not alone in terms of having a more active water master who engages in actual planning as opposed to resolution of disputes or monitoring. The San Gabriel Water Master has a pretty active function, and if you've been following what's going down in West and Central Basin, there's an effort to try to change them into being a more active water master. But in this instance, Water Master was specifically established as broadly, as what Bloomquist called in his book, Dividing the Waters, a polycentric form of management. And that is that it intended to represent different interests. It wasn't intended to be a neutral. That by having all of the competing interests at the table, discussing problems, and all with skin in the game. Anybody who was producing water who had an interest in the basin had skin in the game and was entitled to a voice. And so it was this polycentric form of management that became reflected in the original 1978 judgment, and of course that has also evolved through time.